Good afternoon, thank you for the opportunity to share my work today. I have to admit that this was very challenging because my doctoral research focused on youth justice in Italy in 1930s, in a period in which we have only the Supreme Court and obviously neither the European Courts of Human Rights and Court of Justice. So today I would like to share with you the first partial results of a different approach, obviously. I asked myself whether if it's possible to place criminal case law of Italian Supreme Court in a hypothetical comparison with the jurisprudence of European courts concerning the youth justice. In other words, I'd like to reconstruct a dialogue in a slightly unusual way, not only in a contemporary perspective, but across time. The purpose of this course called Cross-Temporal comparison is to explore if in the field of juvenile justice we can detect the same broader transition that marked the European legal culture, movement from a monistic, law-centered national system to a pluralistic, multi-level one. Tension between monism and pluralism became central because from the 19th century paradigm of judges as mere bouche de la loi, judicial role has evolved into an interpretative authority over codified law. Today, international courts go further, exercising a form of judicial normativity that actively contributes to production of law within a multi-level and pluralistic framework. And that's for this reason that, in my opinion, this could lead me to interesting new perspective. And so I'd like to have a quick look to some case law that I studied. And let us begin with Italy in 1930s, because the Italian Supreme Court offers several revealing decisions that illustrates how a monistic legal culture approach juvenile justice in 1930s. The first one is Colla Pietro case. A 50-year-old boy was convicted of causing serious injury while suffering from partial mental infirmity, and the court emphasized that capacity to understand and to will must be evaluated concretely in relation to the act. This introduced an individualized assessment, but the focus of this sentence, of this decision, is to correct application of Article 98 of Italian Penal Code, that regulated minor criminal responsibility. So values are in the background. The second case is Campo. Here the court faced the question of jurisdiction when a defendant had committed a crime as a minor but turned 18 by the time of the trial. Supreme Court ruled that competence depended on the age of the offender at the time of the crime, not at the trial. But even in this case, this decision reinforced the matter of jurisdiction and values are again in the background. Then the case of Urbanic, yes, exemplifies that the repressive nature of the Italian system. Juvenile convicted of a serious crime was mandatorily enclosed in a reformatory. And the judges argued that the gravity of the offense proved the child's dangerousness. The intention was to ensure that the Italian law on juvenile justice was effective, and even in this case, values were in the background. But now we have to move to Strasbourg, and we can see a very different perspective because in these three cases we can see a different approach to juvenile justice. In this first case, T versus United Kingdom, a 10-year-old boy was tried in an adult crown court for murder, and the European Court of Human Rights held that this violated Article 6 of the Convention, the right to a fair trial, because minors must be able to understand and participate in proceedings adapted to their age. Another landmark decision is Tyrer versus UK again. The applicant, a 15 years old, had been sentenced to corporal punishment, and the European Court held that this be a degrading treatment under the Article 3 of Convention. Third case is Bomar versus Belgium. and it concerned a minor repeatedly placed in adult prison under the pretext of protection. The court found a violation of Article 5, stressing that minors cannot be private of liberty in conditions designed for adults. Taken together, these three judgments shifted the focus from legality to values. International law itself became the tool for promoting a different vision of the rights of the child, a vision that the national legal system were required to respect. And finally, let's turn to Luxembourg, where the Court of Justice has contributed to implement child protection in the European legal order. And the first case is MS and others, in which the court reaffirmed that minors accused of crimes must enjoy procedural guarantees, the right to information, legal assistance, and appeal. These safeguards are essential to ensuring the fairness of proceedings involving children. Second case, again in Italy, is Pupino. The court required the national judges to interpret domestic law with the EU framework decision to guarantee protection for vulnerable victims, like children. And finally, the case of Piotrowski, in which the court held that execution of European arrest mandate against a minor could not proceed without respecting the minimum age of criminal responsibility. Even within its limited competencies, the Court of Justice in this field contributed to today's pluralistic legal order, promoting safeguards for minors across Europe. And so let's move to the first conclusion, because these cases summarize as tracing a trajectory from monistic, law-centered legal culture to a pluralistic, multi-layered one. I realized that the true turning point is the incorporation of human rights into judicial decision. While the Italian Supreme Court was bound to the strict application of codified law, the European courts, more European courts of human rights, placed human rights and increasingly the rights of the child at the heart of their jurisprudence. This innovation turned the European courts into engine of legal development, because free from constraints of legalistic system, they reinterpreted legality through the principles of dignity, liberty, and fairness. In many respects, this anticipates the role of constitutional courts that gradually emerged in Europe in 20th century. However, I should emphasize that these results are only a partial and form a part of an ongoing project, because in preparing the paper to be presented after this conference, I intend to further explore this comparison by examining other cases that better demonstrate transition from a monistic to a pluralistic juvenile system in Europe. But my working hypothesis is, which I present here with caution, is that the shift from monism to pluralism has been driven precisely by the introduction of human rights in judiciary. The more that human rights have been refined, specified and expanded, the more European legal system and juvenile system have opened themselves to new perspectives and new layers of protection. I think that there is much work to do, but I believe that it can provide a promising approach to understand the long-term transformation of youth justice in Europe. So in this sense, youth justice could be not only a reflection of legal history, but also a laboratory for its evaluation. Thank you.